So, what are the steps in a criminal trial? General steps in a criminal trial. If at all somebody gives a complaint against you in a police station, we get panicky if police calls us and informs us that there's a FIR filed against us, and we run to courts to procure anticipatory bail, or else we try to meet some known sources, political leaders, etc., etc., and we do all such kinds of activities whenever we come to know that there is a case registered against us in a police station, which is not at all necessary in the eye of the law. When a case is registered against you and the police informs you to come to the police station, try to cooperate with the investigation. Because I will right now brief the steps that are taken by the police. What exactly happens when an FIR is registered against you? And then first, somebody gives a complaint against you, and if there is an offense that is in the eye of the law called a cognizable offense, a cognizable offense is an offense which is prescribed by the criminal procedure code as an offense in which police are entitled to investigate. So FIR is registered against you, then FIR is registered against you. It is the discretion of the police to register the FIR. So it is a power that is vested only with them. Now, once FIR is registered, police starts the investigation. They they reach the scene of offense. If it is any sort of crime will have a scene of offense. So they will prepare a rough sketch of the scene of offense. They will approach the scene of offense and they will start investigate. They will collect the evidence by examining the persons who witnessed the crime. So who are called prosecution witnesses. And then police also meets the accused if at all accused is within the reach. Sometimes a notice is also issued which is called 41A notice, and he also takes statements from the accused. He also takes statements from the witnesses. He also collects two witnesses who are called punch witnesses, two respectable witnesses who accompany the investigating officer for seizing the material objects that are used in the crime. So once the police starts the investigation, he collects the witnesses, the statements from the witnesses, collects the statements from the accused, collect the material objects or seizes the material objects in the presence of two witnesses who are called punch witnesses, and then he prepares a detailed investigating report, detailed report. If from the entire investigation he comes to know or he comes to conclusion that there is no offense as alleged by the complainant, he files a negative report in the court. When a negative report is filed in the court gives notice to the complainant because he filed a negative report. When a positive report is filed in the court gives notice to the accused. Till then, whosoever is the accused has nothing to worry. So when court gives notice to the accused, court summons the accused. In the language of the court, it is called summoning the accused. And when the summoning order is passed, filing of a police complaint, filing of a charge sheet by the police or a final report by the police, and summoning the accused, there is an examination of the entire file by the judge. or the magistrate who is called in a criminal matter is called the magistrate. The magistrate examines the entire file filed by the police, entire report filed by the police. Magistrate comes to the conclusion that there is a case. Pursuant to coming of the conclusion by the magistrate only, the accused are summoned to the court. Summoning order is passed and accused are summoned to the court. So, uh, once the summoning order is passed, all the witnesses' statements are submitted to the court. The rough sketch or the crime scene is submitted to the court. The material objects that are seized are, that report is also submitted to the court. The accused statements are submitted to the court, and there could be other post-mortem reports, etc., etc. Also, if it is a murder case, autopsy report, the inquest report by the Tahsildar, all these are the entire material which fixes the accused is submitted to the court, which is examined in detail by the magistrate, and then a summoning order is passed. Once the summoning order is passed, once you stand before the judge, once he frames the charges, because the charges that are, the sections that are in the FIR, the sections that are in the police report, the sections that are in the charge sheet or police report or the charge sheet, all could be different. And the sections that are fixed by the court after coming to conclusion, those sections are informed to the accused. And accused is asked whether he pleads guilty or shall suffer a trial. And basing on the answer that is being given by the accused, if at all he pleads guilty, then he is punished then and there. If at all he pleads not guilty, then he has to suffer the trial. And once he has to suffer the trial, what happens? That I will post it in another video, part 2 of the same. Thank you.